Welcome to this very janky video about make masks mandatory and the legal issues that you're talking about when you're joining in this online discussion about how to make a response to outbreaks of COVID-19. Janky, yes. Rushed, yes. But good, maybe, probably not, but let's roll. I am Mark Fletcher. I'm a PhD student at the ANU School of Politics and International Relations, with just the most amazing supervision panel that I could ever hope for. Along with some incredible colleagues and mentors, I study the public understanding of law. My thesis is about interception warrants in national security law, but I maintain research interests in constitutional law, electoral law, and defamation. By trade, I worked across a few different areas of public policy and legal policy, which, if you're really keen, you can stalk my LinkedIn for details. One of my goals in this video is not to rely too much on my background to make the point, but to enhance the viewer's ability to work out their own opinions and views for themselves. I want to put together some very quick resources related to my research that are more public-friendly. Rather than tell you the answer, I want to look at areas of law where you can reasonably disagree on what you want from the legal system. As you can imagine, I see lots of public debates where people make completely wild claims based on what they understand the law to be, and when you say, that's not the law, they freak out because they feel like their opinions should lead naturally and inevitably from a correct statement of legal facts. This video was not what I intended as a pilot, but a debate has erupted today about how the state should respond to outbreaks of COVID, and this is a good chance to experiment with format and how quickly I can churn out topical content. Preferably, I hope, with decreasing levels of jankiness. The hashtag trending today is hashtag make masks mandatory. There is a belief, very much driven by journalists and PR folk on Twitter, that the New South Wales government simply is not doing enough by not responding with a severe crackdown on social activities, including making the wearing of face shields compulsory in some sense. The sentiment is part of a cluster of related sentiments about how New South Wales should respond, using Victoria, which recently came out of one of the world's strictest regimes, as a model. For this discussion, we can park empirical questions about whether or not Victoria and New South Wales are comparable cases. I have views, maybe you do as well, about whether this is a factually grounded discussion, but that's beyond the scope of what I want to cover here. Because what I want to look at is the legal aspect. What does it mean to make something mandatory? And what do people mean when they say they want it to be mandatory? And what other options are there? And how do you weigh these options? If we mean mandatory in its ordinary, regular sense, we mean that the state can coerce people to force people to comply. And to do that, there's a penalty. You do X, else we, the state, will do Y to you. Pay your taxes or we will fine you. Pay your fines or we will imprison you. Obey the road rules or we will take your license away. Don't drive without a license or we will imprison you. This is basically what we mean. And you might have some weird understanding of mandatory, which I've experienced online, where we might want something to be mandatory, but without the penalty attached. What if we had a system of warnings? Wear a mask or we will warn you. But warn you about what? That if you don't comply, there's a penalty. And one thing that I'm going to show is that this liberal version of mandatory without punishment actually ends up getting you to roughly the same system anyway, even if the idea were coherent. And it's about how contact with the police works. So a police-led response is about giving the police powers to engage the public if it thinks there is non-compliance and to issue penalties for non-compliance. There is some technicality here that you don't really need about the types of penalty and how they work, because we're really concerned about this point of contact. If you want the state to make something mandatory, you need a way to enforce it. You need somebody to enforce it. And states have available to them a well-trained organisation that already has a number of powers related to enforcement, and where the rules about their engagement with the public are already fairly well known. And I mean that as a value-neutral proposition. The Police Act 1990 and the Law Enforcement Powers and Responsibilities Act 2002 are real. Relevant lawyers know how they work, and you don't need to make up something from scratch. We can take this off the shelf and apply it to the problem. But we know what this option entails. Even if we're not down the all cops are bastards end of the spectrum, there is a price to pay for this option. Most normal people think that the ordinary person should be able to go about their day without interference by the police. I can walk home from my place of work, and a nosy cop is not allowed, without reason, to ask me to produce ID or to explain what I'm doing with my life. It loosely ties back to this old case from the 1700s called Entick and Carrington, which was about authorities raiding a person's home when they thought they just had a general power to do so. The court said, "Show me the law that allows you to ransack this person's home," and the state went, "Your Honour, it's the vibe of the thing because this is how we've always done it." And the court went, "Lol, no, if you can do this, you need positive law to say that you can." So when should police be able to make contact? We can think about this in terms of concentric circles. You're going about your life in a fairly ordinary way. What moves you from that circle into the contact circle? Maybe there is some reason that the police suspect you of doing something. Maybe you're in a special area where the police have enhanced powers to stop and search. And then, when you're in that circle, what stops you from moving into the next step of actually being under investigation, which I'm using really loosely here to describe a few different legal situations. But it's that contact that's relevant. When should they be in contact with you? Most areas of law require the police officer to have a reason, but we know that this does not get applied equally. No matter how angelic the cop, imagine the Archangel Michael inexplicably decides to become a commissioned police officer of the New South Wales. We know that contact with the community is not going to be even. Some areas of the state have more police officers than others. Some community groups have more contact with the police than others. And this is assuming the perfect cop. Imagine that 1% of cops are anything less than perfect. With more than 16,000 cops, we have 160 cops who are going to have contact with these groups. Legal restrictions do not fall evenly upon the community, no matter how well designed they are. You just have to accept this. And mind that I am not down the all cops are bastards end of the spectrum. Cops are one of the most trusted professions in society, like way, way ahead of journalists who are down below even civil servants and lawyers. And this survey is by Ipsos in 2019. Note that this problem of contact with the police is still there, even if it's just warnings. Once the police come into contact with you to give you a warning about not wearing a face shield, you're now in contact with them for other things. If they smell booze on your breath, you might now fall under the police's power to issue you a direction to move on, which carries a $220 fine if you don't leave the area. If you're a bit of a loose cannon and you get really heated when confronted by the police, they can slap you with a fine for offensive behaviour. Or maybe the cop just knows you from prior altercations and now has a reason to take a bit of an interest into what you've been up to. But you might think that there are simply no alternatives. Go hard and go early or we all die. There are definitely alternatives, and given the cost of police first responses, you need to consider them seriously. For example, you can use basic social pressure, information campaigns, and state-issued guidance. And this sort of reasoning is especially important if you're in a jurisdiction with a Human Rights Act. I am not a human rights lawyer, but the serious ones that I know all go through this sort of reasoning process when we're talking about imposing mandatory restrictions on people. Because I'm not a human rights lawyer, I'm going to get straight to the biscuits with the material points rather than explain it in depth. So there's no Human Rights Act in New South Wales. So your response might be, shut up, this analysis is not legally binding, shut up. But practically all intellectually serious engagements with human rights inquiries follow the same sort of model, which a person who was seriously interested in a discussion about law being human rights friendly would follow. The model contains two things that are of interest here. Proportionality testing. Is the restriction proportional to the policy problem that you're trying to solve? And the least restrictive approach test, which asks us to consider at least the possibility that there might be a less punitive way to achieve the same outcome. And if you're serious about legislation being the best that it can be, you simply should go through this sort of reasoning. Because it changes the debate. Is it really necessary to go with a police-led response to this issue? You have a cluster in one space that you've nearly entirely traced with very little in the way of mystery cases. Do you really need to make it a punishable offence for people not to wear a face shield? Second, as we've seen, there are less restrictive approaches that are conceptually open to us, even if they're not 100% effective at obtaining compliance. They might be sufficient to achieve the policy outcome of managing outbreaks. When you do this kind of analysis, the burden is on the side that wants the most restrictive approach. I want to interfere with general public liberties. I need to justify the positive law for why I want this power to be given to the police. And it's a debate. Two people equal in dignity can disagree, but now we're disagreeing in a playing field where it's clearer what the boundaries are. There's no free lunch with the police first response, and we need to be really clear about who's paying for that lunch. If we're worried about an outbreak in an affluent part of the city, we need to be clear that it's people in less affluent parts of the city who are going to have more contact with the police. And we need to engage seriously with the facts of the discussion. Do you really need 100% compliance with the face shields, or is 80% enough when you've got a good tracing system in place? And that is it for this one. There are bits that I liked and bits that I don't. I cut out some content when we discussed routine policing because I thought it got a bit too tangential. Let me know if I was too brutal with this editing. There are parts of it that are a bit wall of texty, and I think it's easier to get through if you can see somebody's face, but I also have a face for radio, so that's why it's all text. But I think this works better as a dialogue, so I'll think a bit about better ways of getting both sides of the issue. Send me your abuse if your best self would send me abuse. I'm on Twitter at Legal Reckoning if you simply must. Goodbye.